The 8th item is breach of fiduciary duties. And if you'll remember back to the first section, we talked a lot about fiduciary duties and the responsibility of board members to be aware not only of written laws, statute, things that they're responsible for, but also to unwritten law, precedent, and their duties. And these are duties of care, duties of diligence, duties of obedience. One of the things that we often get in our office are telephone calls from board members who have suddenly found out that from somebody that they could be sued personally by virtue of them serving on a church board. And so the telephone call goes something like this. They call up and say, is it true that we can be sued personally because we're serving on a church board or a charitable board? And the answer would be, well, I'm afraid to say yes, that's the answer. And they say, oh, okay. Can we get coverage for that? And we'll say, yeah, certainly you'll have some degree of coverage under your general liability, but you should also get a director's and officer's liability policy as well, so that you cover the complete range of risks. And then they'll say, well, what do we need to do to get coverage? And we'll say there's an application form, and we also need to know how you govern yourself. We need a copy of your constitution or your bylaws. And there's usually a long pause on the other end of the line, after which they'll say, well, I know we do have a constitution or bylaws. I know we have one, but I don't know where it is. Okay, so now think about it from our perspective. We've got somebody calling because they're concerned they could be sued. They want directors and officers coverage. They want us to protect them. We need certain information. They have no idea where their governance document is. What kind of a risk do you think they are? And this is very true of a lot of churches. The board members don't have the resources and guidelines that they need. They don't know the rules. They don't know their objects. They don't know the rules about meetings, quorums, voting procedures. They're meeting once a month, and they're certainly arriving with Tim Hortons and donuts and conducting meetings and doing the best job they can, but the problem is they don't really understand how serious their obligations are and how important it is to be aware of laws and fiduciary duties and their own organization's governance document. So one of the things I would say to board members and challenge them to them individually and to organizations is equip your board members with what they need to do the job that you're asking them to do, because they are putting themselves in personal peril of being sued. They are standing in place of other members of the church to govern the organization. And it's not a game, it's very serious. And so as a board member, what you should be expecting when you serve is you need to know about what is it I'm being asked to do. Give me a copy of our church constitution, our bylaws, our charter. I need a copy of our abuse prevention plan. I need a copy of our workplace safety plan or employment, whatever is applicable to your organization, and perhaps the last year of minutes of the meetings when you're coming on board. Because you need to know what your job is and how you're supposed to do it, and you need some perspective as you're making decisions on behalf of the church or charity. Very important. And a lot of times, liability suits relating to a breach of fiduciary duties has nothing to do with the church or the board members deliberately acting negligently in any way, shape, or form. It has to do with ignorance and not understanding how they are to act. And the other part of it is that the number one defense for a director's and officer's liability claim in a court of law is not that there wasn't something that went wrong or happened. The number one defense is that you are showing due diligence. You acted within the scope of your duties and your responsibilities. Regardless of the outcome, you acted properly and you made the best decision. The decision wasn't always the right one, but based on the information you had and the resources that you had and the professionals you called in, that's your defense. Now, as far as individuals at risk in these kinds of claims, certainly anyone who is your director, officer, to some degree trustees, and sometimes even committee members who serve and contribute to your board. Potential sources of coverage for a breach of your fiduciary duties would be your directors and officers liability policy. As far as tips and notes are concerned on this issue, again, as I mentioned, directors and officers liability coverage, if you have it, is a claims-made coverage, which is good news because it contains retroactive feature usually. It means that the board, even though they just obtained insurance, will have coverage for past negligence, and to some degree, your previous board members, if they were sued for something that happened during their time period, will also have coverage retroactively for prior decisions, so long as you have the retroactive feature. There are other aspects and features of a director's and officers policy that should be in your coverage, and certainly is standard in Robertson Hall's Church Protection Plus package, including triple form of indemnification, spousal endorsement, additional insureds, and so forth. But I do definitely recommend to your board that you review your board governance and understand your fiduciary duties as you fulfill your roles. The ninth item is libel, slander, and privacy issues. And this affects any charity that collects and maintains confidential financial, health, and employment records, or volunteer references, criminal record checks, counseling notes, and other sensitive personal information. Long before we heard of PIPEDA and Privacy Act legislation, there was always an obligation for us to protect sensitive and confidential information because we could always have been sued in a civil court for disclosing that information. And in fact, the fines and penalties under PIPEDA are tiny compared to the civil damages that can be awarded in a court for breach of personal information. Again, it is important for churches to understand that the pulpit is a public place. It's not a private place, it's a public place, so things that are said from the pulpit are considered public statements. Whether it's on an issue of somebody's behavior, whether it's on somebody's personal health condition, whether it's on issues of adultery, homosexuality. These are all things that when they're said from the pulpit, they're said in a public context. So as a board and as leaders and as senior pastors and those who speak and communicate, you need to understand that what you are saying is public. And even within any given church, even though we share faith beliefs, we sometimes have different ways of looking at particular issues or how we would address them. So it is a good idea to have certain policies and procedures on what you say publicly, from the pulpit, in bulletins, in print, and in letters to individuals. Third-party sources of litigation, people who have suffered libel, slander, or invasion of privacy could be employees, members, adherents, volunteers, participants, or even donors related to financial records. And certainly understanding how to keep this information confidential, whether it's in locked drawers or off-site. It is good that you have these kinds of privacy guidelines. As far as potential sources of insurance coverage, again, it gets back to a general liability policy. And the reason for that is general liability covers personal injury, which again, simply means an injury of reputation or a disclosure of information. One additional point I'll make that I hadn't yet is that in this day and age, in an effort to try to be disclosing all information and being transparent, sometimes church leaders and board members feel that they have to disclose everything that they discussed. The reality is, in parliamentary tradition, in our society, there are items that can and should be kept confidential. When a church body elects or appoints you as a board member, what they're telling you is they want you to govern on their behalf. And unless you have a pure congregational model where every single vote or issue is put out to the entire congregation, if you have a functioning board, there are times when issues should be discussed confidentially and should not be released, not even to spouses. If you're serving on a board and you start giving your spouse information that's really confidential, you're putting them in a very difficult position because they might just not even intentionally, but blurt something out to somebody else. And it could be very injurious to somebody you're discussing an issue on. And particularly when we're discussing things like people's criminal records, whether they should qualify for serving in children's ministry, whether we're discussing a termination of an employee or a discipline issue related to somebody's personal behavior. These are all very confidential issues and should be kept so at the board level.